There was a bit of fuss on Twitter this week about a new Sikh court, as it's being described. But what I thought this does, it gives me an opportunity to explain how we have these things where people say, oh, why do we have Sharia courts in this country and things like that. But also, it leads on to something that actually does affect people in everyday life when they're dealing with, like, delivery companies and, car parks and things. So, let me begin. Let's say people are having a dispute about something. How do they resolve that? Well, you can go to court about it. One person can sue the other person, and they can, let a judge decide. But as we know, that's very time-consuming and expensive. So what else could you do? Well, let's just say there was somebody you both trusted, and you said, you know what, Harry down the pub, he's a reasonable guy. Let's just see what he says, and shall we agree, we'll just go with whatever he says. Well, of course you can do that. And this is actually recognised in the Arbitration Act, 1996. And what that says is, if all parties agree, then they can use alternative dispute resolution. In other words, they can choose how they want to resolve this matter, and they can let somebody else decide. They could go for arbitration, or they could just go to somebody they trusted. But also you have like these ideas of community courts. So you do have Sharia courts, and you do have this new Sikh court, and there's a Chinese court in Manchester. There's something called the Beth Din, which Jewish people can use. I mean, anybody can use these. Any party can agree to let anybody resolve a dispute. So why do people, why might people opt to go down this route? Well, lots of reasons. I mean, obviously, like I say, one aspect is it's cheaper. Also, the dealings can be confidential. They can set their own rules on this. And it might be that just people feel that, more comfortable knowing somebody is familiar with the culture and with the background. It might be that there's particular ways in communities of how people lend money to each other, that aren't necessarily, in written contracts or have the same rules that normal contractual rules apply. So you've got somebody who's familiar with that. But these little community courts, they're a really tiny part of it, because the main user of these alternative courts are industry and commerce. The biggest users are the oil industry. They have a massive arbitration centre out in the Middle East, which is a nice little sinecure for sort of retired High Court judges. They go out there and they sit there as arbitrators. So why might the companies do this? Well, again, it's cheaper. Also, it's confidential, so they don't have to worry about all their financial information getting out into the public domain. But also, the people making the decisions have expertise in this particular area. Because normally when you go to court, let's say there's, something that's complex about how a business works, trade practices, something like that, or something highly technical. Well, you have to get expert witnesses. And the judge then just decides, having heard, from the expert witness. But the judge isn't, obliged to accept the findings of any of the witnesses. They can put their own decision there. I mean, that's what we always say. We always say that experts cannot give a decision on the ultimate issue. In other words, who should win the case. But if you use a specialist tribunal, then obviously, you can use experts. So, for instance, there might be people out there in the, you do construction work. You'll be familiar with JCT contracts. That's the Joint Construction Tribunal. And that's a trade body that people in the construction industry can agree to use if there's a dispute. So we've got a dispute about this contract. We're not going to go to court about it. We'll just go to the tribunal, because that's all building experts. And, they know how building projects work and what goes wrong on them, and the fact that people always forget to put things in writing, and what the usual sorts of overheads are. So you get these specialised courts. We've got one for art. We've got the Court of Arbitration for the Arts in The Hague, and that resolves things like ownership disputes of paintings, authenticity, and just general contractual disputes. And again, people like to use that because it's private and confidential. Because people don't necessarily want, people to know their financial detailings or what paintings they've got, or, how they got that one from Baron von Julingscar or something. But also you've just got experts doing it. So this, like I said, this is a really standard thing. There's nothing surprising about it. So, you could set your own court up if you wanted. Now, these agreements are binding, and they cannot be challenged in the regular courts unless they're against public policy or there's some other unfairness, like the tribunal didn't follow its own rules. So usually they're used for things like commercial and financial disputes. They have a limited role in family stuff, like, they can't be used to decide, the fate of children. That's something that the regular courts decide. And obviously, criminal stuff is still criminal law. Although I actually did have a case where it was some, fraud, embezzlement within the community. And again, that was actually dealt with by the Beth Din. They sorted out with the parties to, a way of getting this money back. So when that came to sentence, it was like, well, look, Your Honour, this is all being resolved now. There's a bit of restorative justice going on, so please reflect this in the sentence. But unfortunately, instead of saying this is being dealt with by the Beth Din, the Jewish court, I said this is being dealt with by the Shin Bet, which is one of the Jewish security agencies. And it's actually a Jewish judge who just went, ooh, that's a bit drastic, isn't it? But luckily we were able to resolve that. So how does this affect you? Well, it affects you in this way. The Act just says, if the parties agree. Now, the parties can agree after the fact. OK, we've now got a dispute. Shall we agree to let Bob down the pub sort it? But you can also do this as, like you've said, with building contracts and things. But any contract can have an arbitration clause in it. It can say, in the event of any dispute between the parties must first or only attempt to resolve this by arbitration. They can't use the regular courts. And that's an absolute defence to a claim. If there is a contract that has a clause like that, and somebody tries to bring a claim, when you serve the papers, you serve an acknowledgement of service, and it has 3 boxes. It says admit the claim, deny the claim, but it also says the court has no jurisdiction to try this claim. And you tick that box if there is an arbitration clause and say, you just don't have jurisdiction. And, sometimes there'll be a row about whether or not this is true, but usually if you just tick it and send a copy of the contract, the court will go, OK, we can't deal with this. And this is what catches people out, because these clauses are put in all sorts of contracts. And there was a bit of controversy recently where the arbitration clause was on the packaging. So you took delivery of something. It wasn't on the website when you were ordering or anything like that. But, when you sort of sign here for your delivery, you've signed here. There's extra terms and conditions on the packaging. We call this battle of the forms, and this has cropped up before, where, say I send my terms and conditions to you to sign, but then you send me back a signed copy of your terms and conditions. Then, you've won. The last person to get their form in, it's their terms and conditions. And this can go backwards and forwards. But there was a case where basically the people in the warehouse were just signing for goods. It was supermarkets. And they were just signing the delivery note. But that had extra terms and conditions on the back. And in that particular case, they said that will be an exception to the rule, because it's not really fair that the forklift truck driver can bind like the company in a multi-million-pound contract. But generally speaking, these clauses are binding. So always have a read through standard terms and conditions. And like I say, they've been using them on like parking tickets as well. And again, there's the row because it's only when you pay for your ticket and you get, the printout that it's got the terms and conditions on the back. So they're saying, well, actually, no, because you had entered the contract before that you were made aware of that. But if it is something, that you could have been aware of before you entered the contract, then it will be held to be binding. And you've got to be very careful because, the contract can nominate anybody. And, they will often nominate their own industry sort of bodies. And the argument is, how independent are those bodies? So there you go. So be very careful. Anyway, I hope that cleared up a few misconceptions, but also was vaguely interesting and vaguely useful. If it was, please consider clicking, liking, sharing, and all that sort of thing. And at some stage, I will get round to, because like I say, Cappy and Lord Loverduck are just sat over there scowling at me because they're not in the video.